Ocala.
All right, 25 minutes before 11 o'clock. John Fuller is in the studio. It is February 13th. It's important to say the date on John's show because sometimes he has to be in court and he can't be here, but he's here today. John Fuller is an attorney, if you didn't already know, at the law firm of Fuller & Fuller. His wife, Janet Fuller, is the other Fuller at the law firm here in Ocala, located on Northeast 20th Avenue. We'll give you the exact address later in the show. Right now, though, the phone lines are open. If you have a question about something, a legal issue that you might be facing in your life, John is here to answer those questions. The number to call is the WOCA Climate Control Source Hotline, 352-622-WOCA. That's 622-9622. Good morning, John.
Good morning, Larry. It's great to be here. We actually had a couple of weeks this month when I was in court.
Yeah, I know.
I was happy to be here last week, and it's always good to be here. It's a nice break during the midweek, and we really appreciate our listeners. And folks have legal questions, if we can talk about it generally and enlighten them a little bit as to what they may need to do in terms of follow-up legal care, when we think that's helpful, and we want to try to do that. Obviously, each case is driven by the detailed facts of the case, and if you have a case, you've been in an automobile accident, you have a commercial business dispute or lawsuit, complex family law matter involving substantial assets or issues, or Social Security disability, these are the areas that we focus our practice in and specialize in, and if we can help you, don't hesitate to call us. Our Ocala number is 352-547-4292. Our toll-free number is 855-534-2565. We have offices here in Ocala and also in the villages. So if someone in the villages has been in an accident, a golf car accident you see a lot of in the villages. I've had several cases where people have been driving and have been in rather substantial collisions.
I've heard about them, yeah.
Those are street legal vehicles, and they will run 30, 35 miles an hour, and the same laws apply to operating them that applies to a motor vehicle. And if you've had too much to drink and someone that you are in the golf car with has had, if they're impaired and get in a wreck, you have the same rights and claims as you would if you were in an automobile wreck.
Interesting. And there's a state legislator down there in the villages that is trying to create a law that would say if you have a governor on your golf cart that limits it to 20 miles an hour, you shouldn't have to pay that same insurance as somebody who can go faster.
Interesting. You always know the latest, greatest.
Good morning. You're on the air with John Fuller.
This is Kathy. Hi, John. Hi, Larry.
Good morning, Kathy. Thank you for calling in this morning.
This is just my perception from having worked in the social services field. Why does it take so long for a Social Security disability claim to come through? I'll hang up and listen to your answer.
My goodness, I certainly appreciate you asking that, Kathy, and I wish my wife, Janet, who is my law partner, as Larry said, were here today. You certainly would have gotten an answer from someone who specializes in it. I do not know the specifics of the ins and outs of the Social Security Disability Administration. I can tell you that from just observing what she experiences in her practice, there are, you make your application, they're almost always denied in the first instance. Then you go to a lawyer like Janet, who specializes in Social Security. She files the claim for a hearing before an administrative law judge, which is referred to as an ALJ, and they decide whether or not you've been wrongfully denied. If you have, then you get retroactive benefits to the onset date of your injury. But from what I know and have seen in Janet's practice and what she has told me, that it is not unusual from the time you start the case until, if you win it, you get your award of compensation to run 18 months. It's a very frustrating time for people, and Social Security disability for many people is really the last gasp remedy. When there's nothing else, you can't work, you're 100% disabled.
But you have to wait for
Social Security is oftentimes your last remedy.
Yeah.
And Janet sees people who have really tragic injuries or illnesses that are unable to work. The younger you are, and when you become disabled, generally the more difficult, I believe her experience has been in getting the award, because they will normally call a vocational expert, somebody who has been allegedly trained in vocational analysis, who will review the medical records of the claimant and then review the vocational opportunities that fit whatever limitations, and the vocational expert will testify that, well, they're not 100% disabled. No, they can't do this or they can't do that, but they can do X, Y, and Z jobs, and if you qualify for any kind of job, and interestingly enough, it doesn't have to be in the geographical area. I have one Social Security story based upon one case I had in my entire career, and the gentleman, the vocational expert, said that he was not entitled to benefits because he was qualified to be a cigar roller and to make cigars. And
oh, wow.
And they, that was in the Dictionary of Occupational categories, and I think they used to have some plants down in Tampa where they made cigars. I don't know whether they're there or not. This was long time ago. And the irony is that the job that they say you're capable of doing that would defeat your Social Security claim does not have to be available in the economy of the community in which you live. So I doubt if there is any place in Ocala that would want to hire somebody to roll cigars for them.
Not anymore. Maybe there was at one time. I don't know.
Yeah.
Let's go back to the phone. Wow, fascinating answer. Good morning. You're on the air.
Yes, good morning.
Good morning. How are you, sir?
Very good, thank you. I live in a gated community. Most of the lots are around an acre, and in the front, I noticed that my property marker stops about 2 or 3 feet from the road, and on this strip that's there, of course, my driveway goes across it to the road, and my mailbox is there. Is that not my property? And if it is, am I liable for injury on that strip?
Well, without seeing your deed that describes your property, without seeing your survey that shows where it's laid out, what I think you are describing is a situation that you do own the property, and you do own the property to the road. And what I believe may be the situation with you is that in developments, and you're in a gated community, they normally and historically reserve utility easements that run across the first 20 feet or so of everybody's lot.
Yeah.
And while you own the property, you own it as a subservient owner to the dominant right of the homeowners association or what have you to use that property to put in water lines, cable television, electrical lines, telephone lines, and they have the absolute right to come in and dig up your yard and put those underground lines. And if you ever want to go digging out there, you better call someone to locate all those lines for your own safety to begin with. And secondly, if you hit your water pipe, your whole neighborhood's going to be without water, and that's not going to endear you to your neighbors probably. But yes, you own the property, but it is subject to what is normally called a utilities easement. easement. So the
Okay.
actual property that you own every part of it may go to the monument, but between the monument and the road, I would suspect you own it too, but I can't tell you that without seeing the deed
Yeah.
and the survey. But it would be subject to the utility easement, and every community, certainly every modern community,
Right.
has utility easements, and you probably don't see power poles in your neighborhood. If
No.
you walk out, you don't look up and see
Right.
power poles with electrical wires or telephone wires hanging from them, because all of your utilities are underground,
Yeah.
and they have to have a place where they can put them, and it has to be open and available for the whole neighborhood,
Okay.
so that they can be serviced. But
Yeah.
from the standpoint of other ownership, you have the right to use it as long as it doesn't interfere with the utility easement. If you go
Right.
out and build something on it, say you build driveway lights at the end of your driveway, but
Yeah.
you build it in that utility, they have the right to dismantle that if they have to
Oh.
maintain
Yeah.
and service the utility lines.
Yeah,
So
'cause
you
I know-
put
I know
that
all
there
of-
at your peril.
Yeah, all the properties, when I walk through there, they all have the markers are all about 3 or 4 feet from the road, you know.
Yeah,
And
that's exactly what I think it is. But
Yeah.
again, I'm guessing because I don't know the facts to answer you specifically,
Yeah.
but that's what it sounds like.
So supposedly being my property, I'm liable for injury if it would occur on that property, on that part of it.
That would be a likely scenario. There
Yeah.
are exceptions, obviously, if someone is there as a subcontractor doing work on the utility lines,
Okay.
that is there on the utility easement, you would certainly have defenses to that. But
Right, yeah.
if somebody is walking in your lot, your driveway goes to the road.
Right.
Your driveway has a huge crack in the concrete that forms a huge drop-off, and it's dark, and you don't have it lighted, and
Yeah.
you invite them to come over to your house,
Okay.
and they trip and fall and break their knee,
Yeah.
even though it took place in that entryway that may be the utility easement. I think you could still have some liability.
Liability. Okay, well, thank you very much.
My pleasure. Thank
Yeah.
you for calling. Appreciate
Okay.
you listening to the program.
You bet.
Wow,
Bye.
that's pretty scary. Looks like you have another phone call. Good morning. You're on the air with John Fuller.
Good morning. Mr. Fuller, earlier this week, Larry had an interesting news item about a judge who was Facebook friends with the prosecutor, and the defendant in that case asked that judge to be removed. And before I ask my question, I'm a professional, and I have people that I deal with who are not my peers. In other words, they are of a higher social standing than I am, maybe a government official or an owner of another business or something, and we have relationships, friendly relationships, but yet they would be in a position to, they would be above me in the hierarchy. So can't a judge and a lawyer be friends outside the courtroom, but yet inside the courtroom maintain their professional standards, their professional discipline, and remain objective in a case? And I'll hang up and listen on the air. Thank you.
Yeah, thank you for bringing that up. That's interesting.
Well, absolutely. That's a very good question. Judges, when they're in the courtroom, they have duties and responsibilities of being unbiased and fair, treat all litigants and their lawyers the same. And if there's any reason that they cannot be unbiased, they have a duty to get out of the case by what is called recusing themselves. And judges do that from time to time. However, having said that, there is nothing that just because a judge, an individual is a judge and another individual is a lawyer, does not prevent those two individuals from having a friendship, and it happens all the time. And professionals are able to put aside feelings of any special treatment and go do their jobs respectively. And when the day is done, there is absolutely nothing that I know of in the canons of professional responsibility or in the judicial canons of ethics that say that a judge and a lawyer can't share a meal together, can't go on a trip together, can't go fishing together, can't go hunting together. Those are all absolutely appropriate things that are not prohibited. Now, there are things that are prohibited if, for instance, the lawyer and the judge owned a condominium together over at the beach. Now they have a monetary relationship together, and that judge would be unable to hear the cases of that lawyer if there was some type of joint venture or monetary relationship where they had other than just being a friend. If you know, there can be other types of conflicts where if a judge's spouse knows or has some relationship of a professional nature with one of the litigants, the judge will recuse himself. The basic rule is if there's something that would prevent that judge from being fair, then usually there's no question they will withdraw. But they won't let people take advantage of that. You can't judge shop and say, well, this judge ruled against me at a preliminary hearing. I don't like him, and I saw him eating dinner the other night, his family
really?
with the other one, therefore I want him off the case. I don't think that's the case, and that would work. In fact, I know it wouldn't. And the other thing is the fact that a lawyer may have contributed to a judge's judicial campaign. There's
right.
opinions that say that just the mere fact of contributing the allowed there's a maximum, I don't remember what it is, maybe $500, I don't remember, but you can give up to whatever the statutory allowance for any citizen is, and the fact that you contributed to a judge's campaign does not, under any stretch of the imagination, then require that judge to disqualify himself from your cases.
We have another phone call. Thank you for waiting. You're on the air with John Fuller.
Good morning, Mr. Fuller. Always a pleasure to listen to you.
Oh, thank you kindly, and thank you for calling.
Got a question. This new law in the state of Florida where if you're in an accident, you got 14 days, go to the doctor, or you just totally out. Do you think that's going to hold up if this is appealed throughout the court system?
No, I don't. I believe that's a great question. It was immediately posed when Governor Scott ramrodded it through the legislature last year. It is fraught with defects, in my opinion, and it will be challenged. I think it deprives a person of a basic constitutional right, which is access to the court system. And I do not think that it will be held constitutional once it works its way through the trial courts, the intermediate appellate court, and ultimately to the Florida Supreme Court.
Oh, boy, I'm glad to hear you say that.
That's my opinion. I could be wrong.
And I think it's logical and reasonable. It makes a lot of sense. One more quick question. On this foreclosure deal with the houses, too, I needed, what's your opinion about that? I mean, it looks like now the way things are going with the banks, they've got carte blanche. I mean, looks like the poor person out there has absolutely no recourse. I know there's a couple of houses across the street from me that's the bank on, and they're up kind of high, and the houses are darn near falling in. It's a fairly good neighborhood over here. And I think the county at one time had passed a law where they were supposed to keep them up, but they're not keeping these up, and the lawns are not being cut, and there's a really nice house right between two of them, and I don't understand it. But anyway, I'll hang up and listen to your opinion. It's always good hearing.
Well, thank you again. I really appreciate you taking the time out of your day to call us. Those are two very good questions, especially about the PIP law. Foreclosure, that's a real estate area of law, and I don't specialize in that. But let me just say that if the bank has foreclosed a house and it now has title to the house by having foreclosed its lien against the original owner, that bank as the owner, has the same responsibility to maintain that dwelling to the same standards that any other homeowner does. And I don't know whether it's in the county or the city, but they have both county and city code enforcement boards. And if it violates any of those ordinances in the city or county code, then you can call your county office or the city hall and speak to the code enforcement division, give them the address of the house. They'll send an inspector out. If he thinks that they're doing something or allowing something to exist that does not meet the code, they will send a notice to the legal owner, whatever financial institution, assuming they foreclosed it. Usually give them a certain number of days to cure the problem. If they don't, then they have to go before the zoning board and show cause as to why they should not be fined. If the county goes in and if it's a hazard because of whatever reason, it's falling down, the county has the authority to actually go in and order it destroyed if it's can't be made safe and it's a danger to the public. But that would be about as much information as I could give to you over the phone, over the show here, on the show here.
If you have a question for John, feel free to call in. We've got about 5 minutes left. It's the WOCA Climate Control Source Hotline, 622-WOCA. Just real quickly to interject, the subject of the lowering of the speed limit available to a golf cart to 20 miles per hour. That was what the state representative was trying to propose to lower the insurance rates. Do you think that would go through? Just kind of an observer?
I honestly don't know.
20 miles an hour is enough to get hurt.
Yes, it is. The golf cars that are street legal have requirements of headlights, brake lights.
Yeah.
They have to have windshield wipers. They have to have a horn. They have to have rear view mirrors. They have to have all the safety equipment. They have to have seat belts. They have to have the safety equipment of an automobile. I don't know, and a golf car is not covered under your general automobile insurance policy. If you've got a golf car and you're operating it as a transportation vehicle like they do at the villages all the time, you have to have a separate insurance policy for your golf car.
It sounds like it's $800 what the news item said.
I don't know, but most people down there do have it because they're familiar with the exposure.
Right.
If they don't have it, the question of whether or not a law that limited them to 20 miles an hour. First of all, you'd have to get the legislature to do that, and I suspect that there are people that own golf cars who use them would be opposed to that, because if you live on one side of the villages and you want to go to the grocery store and you don't want to drive your automobile, and the way they've got the infrastructure set out, you really don't need to, and I think most of the people there prefer to use their golf carts. And so if it's limited to a speed that makes it impractical to use it as a realistic modes of transportation, I would think it would meet with some public objection to it. Whether or not the law, you could get it passed and it would stand muster that you had to then limit what an insurance carrier could charge because of a certain speed limit. The laws that have been designed to supposedly give insurance benefits to the consumer have largely never done that in my experience. They according to a lot of statistics, and you can get a lot of debate on this, and it's a hot topic. I don't mean to offend anybody, but most of the savings that comes from premiums goes into the coffers of the large corporate insurance companies. You never see it going back, to the insureds.
By the way, not to give you an unfair question that was so close to the end of the show, but there was another proposal in Tallahassee to mandate liability insurance to gun owners. And it was a hot topic. We had it one morning after I read about it, and it sounds like just another way to discourage people from owning guns.
I think that whole area is an area of great concern that I would like to take a show, and we don't have enough time because there's so many things interrelated with it. I am very troubled that isolated tragedies that are without question horrific tragedies are being used by people with political agendas to limit the constitutional right to citizens to have firearms and to protect themselves. And perhaps next week or a week or two down the road, we'll talk about it. I've actually thought about it, Larry, about introducing it in the show. It's a little bit one of those questions that has a lot of political overlay, and we try to help people with individual questions. But but I do think that we have to be vigilant against intrusive government. I'll end on this note that was an enlightening moment for me that made me re-examine my opinions about the importance of gun ownership and the freedom of types of guns that citizens can own, provided they're law-abiding, they have a permit, they qualify, they're not a convicted felon. Was in 2005, Hurricane Katrina, I believe it was, completely devastated New Orleans. They had no lights, they had no water, they had no law enforcement, they had no fire coverage. Everything was flooded. They had no food, or the people that had food were targets for roving gangs. Some of the gangs that the helicopters on the television showed were going to department stores, breaking plate glass windows, taking television sets. And what was so ironic was that some of the people who were doing that were law enforcement officers in uniform who were doing it. And it showed what a scary, thin veneer of control our society has when all institutions are suspended because of some act of nature that prevents you from getting your friendly law enforcement officer to come to your aid and assistance. If an angry mob is breaking in your front door because you may have a generator and a refrigerator full of food, or expensive silver or televisions or monies or jewels or things of value, and when the government says you can only have a gun that will only shoot X number bullets, I think that goes too far. That's personal opinion. I respect other people's opinions on it, but certainly in New Orleans in 2005, there were gangs roving the streets, breaking into homes, 20, 30 people in the gang, and it would be, in my opinion, much more reassuring to have a weapon available that held more than 10 bullets, and I think that is something that has to be factored in. Certainly, we don't want to have the kind of mass killings that we've seen in Connecticut, but there are other aspects of that, and it needs to be addressed in a very contemplative, deliberate fashion without people who have strong emotional feelings just trying to push their own agenda.
I think you have a lot of listeners who agree with that. John, what's your phone number?
The phone number at our office in Ocala is 352-547-4292. Our 800 number is 855-534-2565. Law firm of Fuller & Fuller. We'd be happy to talk with you if you have a case that we can help you with.
And the address is 1396?
That's right, 1396 Northeast 20th Avenue, Suite 500.
Okay. John, good show as always.
Thank you. Always a pleasure. Thanks to all our listeners.
Always flies. Thank you. We'll take a little break and be right back with Dr. Riyad Fakhouri on the Head to Toe Care Show.
Okay.
Ocala's information station, 1370 WOCA. Ocala. ABC News Now, I'm Daniela Bellotta. It appears the biggest manhunt in Southern California is over. They're waiting for DNA tests, but police are confident the charred body pulled from a burned-out mountain cabin is that of fugitive ex-LAPD cop Christopher Dorner. A standing ovation greeting Pope Benedict, who faced his followers for the first time today since his bombshell announcement. The Pope telling his audience at the Vatican that he's stepping down for the good of the church. President Obama putting his job creation back on the front burner in his State of the Union address, but